Good afternoon, everyone. I'd like to welcome you to this afternoon's webinar presentation. My name is Kathy Purdy. I'm a marketing manager here at Schoeneck King. Today's presenters are Phil Zacchio and Jane Sovereign, both members of Bond's higher education practice. Just a couple quick housekeeping items before we get started today. Please enter your questions through the Q&A box located at the bottom of the screen, and Phil and Jane will do their best to address those questions as time allows. Once the webinar has ended, if you would take a moment to complete the brief survey, we would greatly appreciate that. So to get our program started today, I'm going to hand it to Phil Zacchio in our Syracuse office.
Okay, thank you, Kathy. On behalf of myself and Jane, we'd like to welcome you to today's program to discuss funding under the new and improved Coronavirus Response and Relief Supplemental Appropriations Act. We'll spend the next 45 minutes talking about parameters for use of these funds, when, how, and for what purposes your institutions can deploy the new funding. A couple of upfront notes or caveats on all of this. First of all, we all need to realize this is a moving target. You will all recall from when the CARES Act, the original CARES Act, was adopted last year. In the weeks and indeed in the months following that statute becoming effective, the United States Department of Education came out with a series of guidance pieces thereafter. And some of those imposed additional requirements or restrictions on the use of funds that institutions were not aware of from reading the law originally. They changed over time in different ways. Some of them were challenged by way of litigation. And I think we can expect the same thing with respect to this stimulus legislation as well. DOE has, as I think most will be aware, has already, and to their credit, promptly after the enactment of the legislation, put out a set of FAQs and some other educational materials on their website. But as we will see as we go through our discussion today, there are nevertheless still a number of unanswered, unresolved questions and issues. I think we can expect ongoing guidance from DOE on these and other points. So as we go forward from today, it is incumbent on all of us to keep our eyes open and to watch for and listen for those developments as they come out of DOE over time, because again, they may change, alter, increase the obligations and the parameters for use of these funds. The second thing, just again, upfront, the provisions we're going to discuss today are those that are applicable to public institutions and to private nonprofit institutions in general. There are different allocations and different rules that apply, some of them anyway, to HBCUs, to tribal colleges, to other minority serving institutions, and to proprietary institutions. From judging by our attendee list, I don't believe we have many, if any, from those constituencies on the call, but if you fall into any of those groups, just realize that there may be some requirements that impact differently on your respective institutions. Next slide, please, Kath. So again, the act went into place when it was signed by the president, the then president, on December 27 of last year. And it makes new and increased generally allocations for stimulus relief available to colleges and universities. And when I say increased, that is by way of comparison to the CARES Act. The formula for allocating the funding as among participating institutions is also different. We're not going to spend time today going through the formula in any detail, as you will see the result of that come through when you view your respective awards being made available by the department. But the short version is the formula cuts across a number of different calculations, including Pell and non-Pell in-person learners, both by full-time equivalent population as well as by head count, and also a small amount of funding made available by virtue of an institution's population of distance-only learners as well. You see the heading on the slide here too, Higher Education Emergency Relief Fund, referred to this way A, because that's the way the statute categorizes it. B, because this is the way the department is doling out the funds and is funding what it has called institutions here accounts as originally established under the CARES Act with the new funding as well. In order to get this funding, if your institution received CARES Act funding for both the institutional portion and the student grants portion, there is no application required. The department will automatically allocate funding for you. But the takeaway that's important here is that you must make at least an initial drawdown, not all of it, but an initial drawdown from your funding on or before April 15th of this year. If you don't begin to draw the funds down by April 15th, the department reserves the right to conclude that you're not interested in receiving the funding and therefore to deobligate the funds from your G5 account. If you're an institution that did not take CARES Act funding, then April 15 is significant in that it is an application deadline. You have to affirmatively apply for that funding if you didn't get CARES Act funding, and the application needs to be received by the department by April 15th. There were some institutions under the CARES Act that took the student grant portion of the funding, but for optical or other reasons didn't take the institutional portion of the funding. Those institutions will automatically get a student grant portion allocation under this new legislation, but would need to affirmatively apply for the institutional portion. And we'll get to what those are momentarily. Next slide, Kath. The allocations of funding under the new legislation follow the same basic structure as that which was established under the CARES Act, and that being two main buckets, funding for institutional uses and funding for financial aid grants to students. Within the institutional category, there is a portion of the money can be used, A, for defraying or reimbursing institutional expenses, and we'll get to what those are shortly, but also for institutional expenses for particular student support activities. And then again, a component, as there was under the CARES Act, for financial aid grants to students. The important takeaway here is that the authorized uses in both of these buckets are broader than they were under the CARES Act. You can use funds under the new stimulus legislation for things that were not eligible for funding under the CARES Act. And again, we'll touch on those specifically as we walk through our conversation today. Like the CARES Act, the new stimulus legislation does carry an obligation, if an institution accepts funding, to continue to pay its employees and contractors. And again, the operative phrase here is the same as it was under the CARES Act, an opportunity to continue to make payments to the greatest extent practicable. You'll recall that under the CARES Act, the department issued and to date has still issued virtually no guidance as to the meaning of the phrase "to the greatest extent practicable," other than acknowledging that this decision needs to be made with an eye towards the unique financial circumstances of each institution. And so we don't have a real reliable roadmap as to the level of diligence that's required there, or in particular, when can an institution stop paying folks by way of furlough or contractor termination, that sort of thing. I think our guidance here remains the same as it was under the CARES Act, and that is and this may be an area of audit down the road, if you are in a situation where you have implemented or are implementing things like furloughs or other cutbacks, salary reductions, and so forth, you need to be prepared to show to the department, if they inquire, that you gave a degree of good faith consideration to alternatives. In other words, show that you did your due diligence, show that you evaluated whether other things besides ceasing payments would suffice to enable operations to continue in a way that was adequate for your purposes, and be prepared to demonstrate that you did a good solid kicking of those tires before you resorted to ceasing payments. Again, this is no different to this point than it was under the CARES Act. The other thing to note here in terms of an allocation, there is a reduction for those institutions that are required to pay the so-called endowment excise tax. that was adopted under the 2017 tax reform legislation. And this is calculated for tax year 2019. If you are an institution that is required to pay the endowment tax for your tax year 2019, you are only entitled to draw 50% of what would otherwise have been your formula-based allocation. And the uses to which you can put that 50% are also limited. You can use it for emergency financial aid grants to students, for what the legislation refers to as sanitation expenses, purchase of PPE, and other expenses that are directly associated with the health and the safety of the campus environment. That is it, and notable by its exclusion is a potential use to compensate the institution for lost revenues, which, as we will see, is a generally accepted use of the institutional portion of the new stimulus funding for other institutions. A couple of additional notes in terms of the endowment tax institutions. Number one, there is an affirmative obligation to notify the department if you are an institution obligated to pay the endowment excise tax. If you've determined already that you're obligated to pay that, then you need to notify them now. If that determination is made in the future, there is a specific form for this that needs to be sent to the department within 30 days after the institution concludes that it's obligated to pay the endowment excise tax. There is a waiver process for this. An institution that is subject to this haircut and limitation on use because it's paid the endowment excise tax can apply to the department for a waiver of those provisions. And the criteria for granting the waiver have not yet been articulated by the department, but it presumably will involve some articulation of need, notwithstanding the institution's the size and configuration of the institution's endowment. The other thing to note here, institutions will have their full formula-based allocation made available to their G5 account, even if they are subject to the endowment tax. And the way the restriction works is that you are not entitled to draw that past the 50% line if you're subject to the tax. So there is a self-accountability provision here. Merely because it's there, if you are subject to that endowment tax, does not mean you can use it. Next slide, Kathy. I mentioned before that just like the CARES Act, our new stimulus legislation divides money between institutional uses and a required use for student emergency financial aid grants. One difference here is the proportionate allocation. You will recall that under the CARES Act, each institution needed to spend at least as much on financial aid grants to students as it did for institutional funding. Dollar for dollar, 50-50 split. The new legislation is different, and it provides, as a general rule, that an institution needs to provide the same amount in raw dollar numbers, not percentage, but raw dollar numbers in student emergency financial aid grants as it was required to provide under the CARES Act. So you see the example on the slide. If you've got an institution that received $2 million in CARES Act funding and therefore had to provide $1 million in student financial aid grants, and it now receives $3 million under the new stimulus legislation, it will still be required to provide only $1 million in financial aid grants to students. The other $2 million becomes available for institutional use. Because most institutions are receiving more money this time around than they did under the CARES Act, for most institutions, this is going to result in an institution having north of 50% available for institutional funding, institutional costs and expenses, as compared to the student financial aid grants. The department continues to encourage institutions to use institutional funds voluntarily for grants to students, but you are not required to do that north of the amount calculated by reference to your CARES Act obligation. One caveat to be aware of here, I mentioned earlier that the formula includes a component attributable to students who were remote-only learners prior to the pandemic. And the formula allocates a small amount of money to institutions that had distance learning only students. If you are an institution that had a significant population of distance only learners prior to the pandemic, it is likely that you will wind up needing to pay more than this formula would indicate for student financial aid grants. The department in making the allocations to G5 accounts has already calculated by reference to the formula how much money each institution is getting for institutional purposes and for financial aid grants. And you will see, if you were one of these institutions with a significant remote population, that your obligation for financial aid grants this time around may be more than what it was under the CARES Act. These are side-by-side columns in the allocation table. If so, that is because you received money attributable to your distance learning population. And so you'll want to take that, and unless you see a manifest error in the calculation somehow, the advice is follow the floor that the department has determined for use for financial aid grants. Obviously, fair to question them if you think that they've got it wrong, but in most cases, if you see more being allocated for student grants than was an allocation under the CARES Act, that is likely the reason for that. Next slide, Kath. The legislation also contains a provision that allows those institutions that still have unused CARES Act funds on hand to repurpose those funds and use them for the new broader purposes that are permitted under the new statute. And this is true for both the institutional portion as well as the student funds, the student financial aid grant funds. The one caveat here is that if you repurpose unused CARES Act money, you have got to ensure that you continue to use at least 50% of your original CARES Act allocation for financial aid grants to students, but those grants can be made either within the parameters authorized by the original CARES Act or parameters that are, as Jane will describe for us in a little bit, broader under this legislation. So you can do it either way. The one thing that this provision does not do, if you received money under the CARES Act and you used it for a purpose that was not permissible under the CARES Act, but would be permissible under this new legislation, this, at least to this point, does not bless that retroactively. It does not clean that problem up. That is still something that the department reserves the right to raise in auditing CARES Act use. The other question that is unanswered here is whether this repurposing provision also extends what would have been the CARES Act deadline. As you'll recall, under the CARES Act, you're required to use your funding within a year after you received it back last spring. It is not clear at this point that this repurposing, even though it allows you to use that unspent money if you have it for the purposes allowed by this new legislation, it is not clear that that also correspondingly increases the deadline to do that. This is hopefully something that the department will be clarifying in fairly short order. Next slide, please, Kath. So I mentioned before that the permitted purposes for use of institutional funding and student funding as well, and Jane will get to that, but we're going to cover institutional funds now. The permitted purposes for use of the institutional funds bucket are broader than they were under the CARES Act. Most notably, expenses don't need to be specifically related to changes, in particular to the delivery of instruction due to coronavirus. That was the standard under the CARES Act. It isn't any longer. Now the authorization is to use funds to defray expenses associated generally with coronavirus and institutional response to coronavirus. And you'll see on the slide a list of a non-exclusive list of eligible expenses. Some of these are very similar to what we dealt with under the CARES Act. Technology costs associated with transitioning to distance ed, faculty and staff trainings, but then some much broader authorizations here. Payroll, and in particular, the authority to use the stimulus funding to reimburse yourself for lost revenue attributable to or associated with the coronavirus. So again, broader authorized use than was the case under the CARES Act. You'll see a final bullet here that mentions that the costs must have been incurred on or after December 27, 2020. This is an issue that bears watching. The department, in rolling out its guidance on HEERF 2, articulated this both by way of a fact sheet and also, more importantly, in the agreements that each institution is deemed to accept when it elects to draw down money under the new legislation. This draws its origin from federal uniform guidance for all federal grant funding, and in particular, a limitation on pre-award costs that can be used with federal grant dollars. And the standard there is generally that pre-award costs need to have been incurred in reliance on negotiations and in anticipation of receiving a federal grant. And the department interpreted this to mean that an institution couldn't reasonably have anticipated getting HERF2 funding until the law went into effect. Therefore, costs to be reimbursable need to have been incurred on or after the date that the law went into effect. We are aware of the fact that on a webinar recently, an official from the department, in what was her last day on the job just prior to the transition in presidential administrations, articulated a belief that these funds actually could be used to compensate institutions for costs incurred during fall 2020 and perhaps even spring 2020, at least subsequent to the onset of the pandemic. To this point, we're not certain how she got to that, given the very specific information that the department has put out on this point. But this bears watching. Obviously, that kind of a limitation was a bit of a shocking surprise to institutions, many of whom incurred the lion's share of new costs and lost revenue last year, as opposed to this year. We have heard word that the DOE, in conversations with individual institutions, may be on the verge of giving more updated and potentially more flexible guidance as far as that is concerned. But this is, again, to this point, a line in the sand that they have drawn time-wise and something to be aware of. Next slide, please. Like the CARES Act, the HERF2 funds carry a similar list of prohibited uses for the institutional portion of funding. You see them on the slide here. Again, these will virtually all ring a bell from the CARES Act. Payment to contractors for pre-enrollment recruitment, institutional marketing or recruitment expenses, the establishment of endowments, capital expenditures for athletic facilities or facilities associated with sectarian instruction or religious worship, or benefits or compensation for senior administrators or executives. The key takeaway here, this is a very likely subject of audit when the department comes in, as it will be under the CARES Act as well, if the department audits your expenditures. You want to be sure that you enable yourself to trace funding use within the institution, and that means marrying these funds up to particular cost items and doing it in a specific way under your cost accounting methodology, so that you can demonstrate to the department, if they come in, that the funds went for permissible purposes and not for impermissible purposes. The other takeaway here is, if you have a menu of potential items to which this funding could be devoted, and some of them are slam dunks as being permissible, and some of them are perhaps more aggressive, the obvious. If you can use all of these funds on uses that are non-controversial and easy to substantiate, deploy the funding there as opposed to trying to get more creative or otherwise. Next slide, Kath. Last but not least, under the umbrella of institutional expenses, just a few important dates. The first we covered already. Funds need to be at least initially drawn down by April 15th. That is the first draw, not all of it, but the first. In fact, you cannot simply draw down your entire allocation under your G5 account in one fell swoop right off the bat, regardless of when you are going to use those funds. This is because, and again, this is under general rules for federal grant funding, an institution is required to minimize the time that it is holding federal funding. And with institutional expenses, there is a requirement that you apply the funds either by way of expending them or applying them internally to previous expenses and attaching them to cost lines within 3 days after drawing them down. When you have the funds, they need to be held, generally speaking, in an interest-bearing account. There are exceptions to that. For example, if an institution does not receive more than $250,000 in the year in all federal funding, or if, based on the terms available for interest-bearing accounts, you reasonably anticipate that you could not be expected to generate interest in excess of $500. In those cases, an interest-bearing account is not necessary, but in all other cases, it is. And ultimately, on an annual basis, the institution is allowed to keep up to $500 to compensate itself for administrative expense, but needs to remit amounts in excess of that threshold to the federal government. Last but not least, again, as mentioned before, the law, just like the CARES Act, carries a requirement that the funds be expended within 1 year after they are obligated to the institution's G5 account. There is an opportunity for a no-cost extension here. Once again, the parameters for which are not entirely clear yet. I think most institutions will be able to deploy funding within this time frame, but be aware that that is a back-end deadline for this funding, just as it was for CARES Act funding. And with that, I will turn it over to Jane to talk about student-targeted expenses.
Thank you, Phil. Student support activities are kind of an interesting new category here. They're part of institutional expenses, but they're very much related to students and really all about students. So these are student support activities. The term is not defined in the statute, but the department interprets the provision to authorize use for activities like TRIO and Gear Up program activities that address the needs related to COVID. The department also gives examples such as transition to virtual activities, purchase of PPE, and innovative learning methods that enable student support activities authorized under the Higher Education Act during the pandemic. I think it's worth noting and reminding ourselves of what some of the TRIO activities are that are eligible under the Higher Education Act, both for those institutions that have TRIO that could presumably do more, and those that don't, for some ideas of activities. Specifically, academic tutoring and advising activities and other services for students, financial aid advising, individual counseling services, and securing temporary housing for homeless students or for students in foster care during breaks. These are activities geared towards students with, with need and with, having, meeting some of the criteria of these programs. This is, I think, a very helpful piece of institutional expenses that may not have been able to be addressed earlier. So I think this is a good opportunity for institutions. These are also subject to the same general considerations that Phil talked about for the institutional expense portion. We don't want to confuse these with the student financial aid grants. Next, please, Kathy. So let's talk about the student financial aid grants. And as with the earlier issues, there are some of the same rules as there were under the CARES Act, and then there are different expectations for this round. So one of the major differences is that these grants may be used for any component of the cost of attendance, and that they may be applied to student balances owed if the student consents in writing, and more on that in a moment. Similar to the CARES Act, they can be used for emergency costs that arise due to COVID, tuition, food, housing, healthcare, mental health care, childcare. The costs don't need, as with this round for the institutional expenses, they don't need to be specifically related to the disruption of campus operations due to coronavirus. I think there was a recognition, a reasonable recognition that that definition was too narrow and not particularly helpful. Again, we have the requirement that the costs must have been incurred on or after December 27th, 2020. Next slide, please. So another major difference is that means testing is now required. If any of your institutions made a determination under the CARES Act to give each student $300, for example, and call it a day, that's no longer going to work. That institutions are required to prioritize funding to students with, quote, exceptional need, such as students who receive Pell Grants. That doesn't mean that students have to receive Pell Grants, but they do have to have exceptional need. And the department notes that institutions should carefully document how they prioritize students with exceptional need. A note that I believe that just yesterday, the department announced, or the administration announced, a number of individuals whom they are planning to nominate or appoint for high-level positions in the department. And there were a couple of very strong through lines on the experience and the interests of these individuals. And they were first having a deep concern about student loan borrowers and the effect on students of various issues related to lending. The other through line is clearly equity for students from different socioeconomic backgrounds, for students with exceptional need, racial equity, and really finding a way to level the playing field. So I think it's pretty clear that some of the direction, in addition to the interests of the secretary nominee, I think these show that there is going to be a very strong interest in putting the student first, in students from who have significant need, and for equity of all kinds. So I think that's kind of a sense of where the department is going. And of course, careful documentation of how they prioritize these students. I'm sure that will be a factor that, if and when there are audits, will be important. Next slide, please. So the eligibility for grants is not a lot clearer than it was before under the CARES Act. So as you know, although the initial requirement was that a student had to be Title IV eligible, that was modified near the end of the last administration for that group of students who have issues such as prior convictions or other issues that, while they might have been financially eligible, they had a disqualification for Title IV. Those students are taken care of. The rule at the end of the last administration that is still in effect is that US citizenship is required. In other words, in order to be eligible for a grant, that you cannot be a DACA student, you cannot be an international student. We don't know yet. We have not heard where the new administration, whether they will be remaining with this formulation or changing it. As I think we all know, there was a tremendous amount of pushback on that under the CARES Act, including lawsuits. There are, I believe, 2 jurisdictions where there are court orders, injunctions still in place, allowing for some groups to receive some of that grant money, and that presumably will continue unless there's a wholesale change under the new administration. And clearly, we've seen that immigration is a high priority for the new administration. We're all still awaiting whatever review is being done of the legal issues on this, but keep an eye out. I'm sure there will be some, at least there will be some addressing of this issue. I note too that as before, a large number of higher education groups and others have pushed on the administration to the department to change those rules and allow DACA students and international students to be eligible. No news yet. Stay tuned. Next slide, please. So in terms of calculation of the amount of the grants, as before, under the CARES Act, the department recommends the maximum federal Pell Grant amount for the particular award year as an appropriate maximum amount for the grant. This is not a requirement. This is not a hard cap. It's a recommendation that it's generally an appropriate maximum amount. But institutions are also encouraged by the department to consider each student's particular socioeconomic circumstances. And here you have, again, the incoming leadership that are clearly interested in this issue. And that institutions, you may have individuals who have terrible circumstances where their needs are significantly above the Pell Grant maximum, and you'll need to develop a process for determining how to work financial aid, student aid, all of your folks working together to figure out a process, because you will need to, similar to your other calculations, you will need to be prepared to demonstrate the basis on which you determine the amount of grants and have that fully documented and available. Next slide, please. The distribution of the grants, again, significant change here. First, the same is possible. That is, that students can receive grants as direct cash payments using the same means of distribution that were authorized under the CARES Act. But the new choice is that students may choose to apply the grants to balances owed to the institution for items within the cost of attendance. Next slide, please. There are caveats on that that essentially go to the point that institutions cannot pressure students to apply the grant to their balance, no strings attached. So institutions may not require a student to apply the grant to satisfy an outstanding balance as a condition to receiving the grant, nor can an institution condition receipt of a grant on a student's continued or future enrollment at the institution. You take people as they are during the eligible period. And per the department, you cannot incentivize students to apply any account balances. For example, no, hey, 10% discount if you choose to, on this particular cost, if you choose to apply the balance. You can't do it, no thumb on the scales, no strings attached. And importantly, you must obtain a student's affirmative or written or electronic opt-in to apply a balance before you apply the money to the balance. It's got to be in advance. It's got to be in writing or electronically, presumably electronic signature, email, etc. You have to have that evidence that the student wants this before you apply the balance. And I suspect if there's audits, this will be a significant issue. upon, as DOE puts it, upon further consideration, they are now permitting similar use of any unexpended CARES Act emergency grant funds in this same manner. In other words, that students can have the choice of having it applied to their balance or received directly. Next slide, please. In terms of timing, similar to really the same as what Phil described before. Initial drawdown, clearly they want these to go to students as quickly as possible. Initial drawdown to start by April 15th. You must disperse or apply funds for the grants within 15 days after drawing them down. The department acknowledges it's not as easy as paying a bill. You may need to find students, but 15 days you have after drawing them down. And then the funds must be fully dispersed to the greatest extent practicable, again, within 1 year after, after they're obligated. Again, extensions may be awarded. The department notes, if you're thinking you need extensions, give us advance notice, ask us in advance, don't wait till the date it's due or after the date. Next slide, please. So I think that's pretty much a wrap on the student grants. I want to kind of echo what Phil said and add to it, that we know this guidance is going to be evolving and changing over the coming weeks and months. As with the CARES Act, this is a statute that was drafted in legislative time very quickly. There's lots of gaps. The enforcement had to start and the implementation had to start very quickly. Institutions really should continue to monitor these developments carefully and continuously. We have the website here for here too. There's the FAQs are on it, and there will likely be more FAQs and other guidance. The supplemental agreements for institutional uses and student grants are on this. And a reminder, of course, to pay attention, as I'm sure you do, to the grant award notification letters that you get. Those contain sometimes new information, sometimes conflicting information, I'm sorry to say, but the department's doing its best, I think, in short order, and will hopefully straighten out some of these things. So I'm going to kick it back to Phil, and let's see if we have, I know we've run close to the time. I don't know if we have a little bit of time for questions.
Sure. Yeah, I think we do, Jane, and we will stay on for a few minutes afterwards just to address a few of these questions as well. For those of you who have commitments and need to run, we understand that, but feel free to stay on and we will take and address a number of the questions that we've received here. Just looking at them, I see a good number of questions on the December 27th, 2020 date and what that means. Among others, a notification here that there's confusion and that the department has contradicted itself. You're absolutely right. Your perception is accurate. The department has seemingly contradicted itself on this. We read one thing and we hear another. I think this is absolutely an area where, and I'm anticipating in fairly short order, we can anticipate some clarification from the department. A couple of particular aspects of this. There are a couple of questions in terms of how this relates to lost revenue. That is an absolutely fair point and a good observation here. The origin of the December 27 date and the limitation on use of the funding that the department has rolled out, as I mentioned earlier, is a generally applicable regulation for use of federal grant funding, and it deals with pre-award costs. Lost revenue, arguably, is not a pre-award cost. And given that the statute itself authorizes use of funding without that limitation for lost revenues, there's at least an argument that the rule ought to be different if you're talking about lost revenues and potentially being able to look back on those as compared to costs that were occurred prior to that date. It is an argument. It is not a lock, solid, slam dunk, cinch argument. It is an argument. But again, this may be a dividing line that the department draws in all of this. This articulation of the December 27 date was the result of the department's career counsel, their in-house attorneys, concluding that there was an applicability of that pre-award cost regulation to this grant funding, which makes sense, but it is interpretive, and it's possible that DOE under the new administration will reach a different interpretation of the applicability of that regulation, or may decide that it applies differently as between costs and lost revenue. The only advice there really is stay tuned at this point. Another question here, also with reference to the December 27th date, but this is on the student side. How does this apply if charges were posted to the student's account for spring 2021? It's attributable to spring 2021, therefore after December 27, but the charges actually posted to the account before December 27. A lot of us have asked that question. It is yet, and please don't shoot the messenger, it is yet another unknown at this point. Again, this is, along with the applicability to international students for the financial aid grants, these two issues are right at the top of our list in terms of a priority for clarification from the department. There was also a question in terms of the April 15th deadline. And the question is this a drawdown out of one pot or money or two? And to which does the April 15 deadline apply? The way this is funded, you will receive, if you haven't already, grant award notifications, plural, one for your institutional fund bucket, one for your student grant bucket. The April 15 condition is stated in both awards. It is a term under the agreement that you're deemed to accept when you draw down the institutional bucket of funds, as well as when you draw down the student grant bucket of funds as well. And the guidance on this sits across the top of both. So whether you only have to draw out of one bucket or two is not it's not explicitly answered, but my answer would be, given that this condition applies to each of what the department considers to be two separate grant awards, I think you want to be making at least an initial drawdown out of each of those two buckets before April 15. And then last, and then I'll give you a chance here for a couple of questions after this, but last, there is a question repeated by a few folks here. Do we need to draw down the student money first before we draw down the institutional funding? The answer is no. There is a requirement that you expend a particular amount as a condition to all of this for student grant awards, but there is no requirement that you spend all of or distribute all of the student grant money before you draw the institutional portion. There is no requirement that you pace yourself dollar by dollar so that you never put yourself in a situation where you've got more drawn out of the institutional bucket than the student bucket. Those requirements do not exist. You can draw quicker out of the institutional bucket than out of the student bucket. Jane, any thoughts on these or other questions that you're seeing?
Just want to add a couple of thoughts on revenue losses. I agree with Phil, it is not clear yet, but I would note that in the some of the other sections of this gigantic law and relating to other laws relating to businesses, that it has been a year, some of them have year-over-year comparisons as a way to measure revenue loss. So I think that there may be some headway we may be able to make some headway in having a one-year look back or some other kind of measure, and that it's not as if everything, you can't go, before December 27th, 2020. So I'm optimistic that we're like Phil, that there will be guidance, whatever the guidance is, but there are some arguments that that there is precedent in some of the other parts of the bill. There was one question about, in terms of determining lost revenue, or that is determining expenditures incurred, were those only attributable to student financial aid grant eligible students? I guess the question was, if eligible students. It seems to me that any expenditures for any students that are enrolled are should be eligible. I don't know if the specific meaning of the question was only those getting financial aid grants. I don't think that's a limitation. Phil, back to you. I'll keep scrolling through the questions too.
Okay, let me hit a couple more here, and then maybe we'll wrap up here at some point. There is a question about the 3-day deadline for drawing down, and what happens in a situation where an institution has incurred and paid an expense and then wants to draw the money to reimburse itself for that expense, assuming it's an eligible cost. And does that drawdown need to happen within 3 days after you've paid the cost, for example, to a vendor or some such thing? I don't believe that's the case. I think the key here is that once you have the money, you tie it to an eligible cost line within 3 days after you draw it down. The fact that you paid the money out of your own pocket previously, I don't think that starts a clock running, in the same kind of way. Now, if the order of operations is the reverse and you're going to draw the money and then pay it, as opposed to simply tying it to a cost item internally, if you're going to draw the money and then pay it, then yeah, I think that payment needs to happen within the 3 days. But if the order is in the way that the question described, then no, I do not think you need to draw the money within 3 days after you incurred that expense. Jane, I think that's all I've got here. Anything else before we wrap up?
I'm going to tackle one and just give you my gut feeling and see what Phil thinks. That great question from a number of people. If the tuition bill hit the student account for spring term before December 27th, 2020, and in some cases the amount's not due till after December 27th, can students, would this be considered an outstanding balance that the grant could be used against? My gut is yes, because how else would you have an outstanding balance during this period of time unless you used what was billed for spring semester? So it seems to me the answer to that is yes, and my gut would be, we'll have to see what, I assume the department will discuss this, but my gut would be any spring tuition, even if it wasn't billed before the 27th. I'm not telling you that's the rule. I'm just saying my gut tells me that's where the department will go, because clearly they want to help students, not just with last fall's tuition, but if they're still having difficulty in the spring. So I think we can expect some guidance on that. I also encourage folks to send that question to the email address for the department with these questions, because if they get enough of these questions, that may prompt them to more quickly send out some kind of advice about that issue. Phil, what are your thoughts on that?
Jane, I would agree that there is a strong argument in favor of that interpretation. Those are costs that students, that are attributable to students after the December date. I'll also say roughly 1 million people have asked this question, and I think to date, the silence from the department in response is deafening. And so I think this all rolls up into the host of other issues associated with the December 27 date. And as you mentioned, I think we just need to wait and see what they say as far as this is concerned. There are just a whole host of institutions waiting on an answer to that very specific question, and we just don't know yet. Well, we just don't.
Right. So one last word on that. As Phil talked about with the issue of when you have expenses that are slam dunks and you have others that are more creative or a little edgier, same thing, I think, for some of the grant expenditures. If you have some clear-cut expenditures that are going to, or students who want this in cash, get out what you can get out quickly and be certain on. And we hope that advice will be forthcoming soon for the more questionable issues.
Okay, so with that, I think we are going to wrap up. I do want to acknowledge, I know we got a number of questions here. We've gotten to some of them, not all of them. I think this is exactly reflective of what we said earlier, the number of unanswered questions that remain here. Please feel free to reach out to either Jane or I If we didn't get to your question and you'd like to chat about it, we're absolutely happy to talk at any time. And again, otherwise, let's all keep our eyes open to what comes out of the department. We will do our best to push out guidance in response to what we see or hear coming out from the department, but this is a collective effort. Let's all keep our eyes and ears open and see where we go from here. So thank you again for being here. Thank you again for participating. Be safe, be well, and we hope to see and talk to you all again soon.
Thank you.